Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 7 of Employment Law Unlocked, where we'll be talking about medical insurance. So what are the objectives of today's episode? The main objective is to outline what the law provides in regards to medical care, medical attention, and medical insurance. So let's get straight into the episode. The law provides, under Section 34 of the Employment Act, that it is the employer who bears the obligation of providing sufficient and proper medicine to its sick employees and medical attention to seriously ill employees. The law expects that an employee who is ill will notify their employer of their illness and the need to seek medical attention within reasonable time. Thereafter, the employer should make appropriate steps in ensuring that the employee is accorded the medical attention they require. This includes paying for the medical expenses of such a sick employee. In the event that the employee proceeds to pay for their own medical bills, they are entitled to reimbursement from the employer. Now, the provisions of Section 34 of the Employment Act do not apply where 1. The employee falls ill while absent at work out of unlawful reasons. 2. Where the employee's illness is out of a self-inflicted action. 3. Where the government provides free medical care for its citizens. And 4. Where there is an insurance scheme that has been provided for under statute. Now, currently, there is an insurance scheme that has been provided for under statute. That is the Social Health Insurance Fund, commonly known as SHIF, that replaced NHIF, and it is provided for under the Social Health Insurance Act. Under that act, it mandates all employers to ensure that they deduct SHIF contributions and remit the same monthly to the Social Health Authority, commonly known as SHA. Once an employer deducts and remits its employees' monthly SHIF contributions, the employer is not obligated to pay for the medical expenses of its employees out of pocket. The employee is expected that once they get ill, they can proceed to go to a medical facility and utilize their SHIF. The law does not provide an obligation to employer to take out private medical covers for its employees. So I'm sure you're wondering, why then do employers take out private medical insurance covers for their employees? And I'll give you 3 reasons why. The first is, an employer may choose to take out private medical cover for his or her employee as a way of motivating his or her employee and also as a way of attracting high caliber employees to their organization or company. The second reason an employer may choose to take out private medical insurance cover for his employees is because once they do so, they are exempted from paying matching contribution to SHA. And I'll explain. So where the employer chooses not to take out a private medical insurance for the employees, on top of the deducted SHIF contribution that is made on their employee's salary, the employer is also expected to match the SHIF contribution of the employee and remit the same to SHA. So in the event that maybe an employer is deducting their employee 1,500 shillings as SHIF contribution, they are expected to also contribute a similar amount of 1,500 and pay the same to SHA. Where an employer has taken out private medical insurance for their employees, they are exempted from paying matching SHIF contributions to SHA. The third reason as to why an employer may take out a private medical cover is because this offers the employees with two covers. The primary cover being the private medical insurance cover, which covers majority of the medical bills of the employee. And the second cover is SHIF, which covers any other medical expenses that may not be covered by the private medical insurance cover. So those are the reasons why employers still opt to take out private medical insurance covers for their employees. The law provides, under the Employment General Rules, that it is a mandatory requirement for employers to ensure that they have the basic medicines at the workplace. Basic medicines could be Panadols, paracetamols, antiseptics, just the general medicine that is used in everyday work life, and they should be accessible to the employees. The law also provides that an employer must ensure that they have at least one first aid kit in their workplace. Further, the law also provides that the employer has to ensure, especially in a case where they have employed more than 100 employees in one workplace, that if that workplace is not near a public hospital or a dispensary, the employer appoints a medical dresser or a medical nurse or a suitable person to take care of any sick employee at the workplace. The law further provides that in the event where an employee falls sick at work and requires transportation to hospital, it is the duty of the employer to cater for the transportation costs. And upon discharge of such an employee, and the medical officer is of the opinion that the employee needs to be facilitated to reach home or to reach the workplace, it is the duty of the employer to pay for the transport costs of such a sick employee, or the medical officer can facilitate the transportation of that sick employee at the employer's costs. The law provides that if the employer does not abide by these rules, they will be found liable to pay a fine of Kenya shillings 10,000 or to imprisonment for a term not exceeding 6 months or to both. Now let us talk about the case of Eddie Mutegi versus Mega Microfinance Company Limited 2012. In this case, Eddie was employed as an administrative officer in 2008, but only received his employment contract in February 2011. It was a term in Eddie's employment contract that he was to receive a salary of 40,000 shillings, was to enjoy 30 annual leave days, and was to be given a private medical insurance cover. However, in June 2011, Eddie received a letter from his employer informing him that his employment contract would expire in July 2011. Now, upon termination, Eddie filed a claim against his employer, seeking a couple of reliefs, including unpaid medical cover, noting that his medical cover had expired in March 2011 and the employer had failed to renew the same. On the other hand, the employer informed the court that yes, Eddie's medical cover had indeed expired in March 2011. However, Eddie was entitled to reimbursement in the event that he had incurred any medical bills. Now, the court was faced with the task of establishing whether Eddie was entitled to unpaid medical cover for the period where his medical cover had expired. The court noted that where an employer had provided for a private medical insurance cover, it was a progressive move made by the employer to ensure that all his or her employees enjoy medical care at all times. In the event that an employer does not provide private medical insurance cover for his employees, it was the duty of the employee to inform the employer of their illness and the need to seek medical attention. Thereafter, the employer was faced with the obligation of ensuring that they make steps that ensure that the employee actually accesses the medical attention that they require. In this case, the court found that Eddie had failed to provide evidence to prove his sickness. He had also failed to provide evidence to prove that he had informed his employer of the need to seek medical attention. Further, the court noted that Eddie had failed to provide court with any evidence to prove that he had incurred any medical bills and prove that the employer had failed to reimburse him the medical expenses. Therefore, the court found that Eddie's claim for unpaid medical cover had to fail. So what can we learn from this case? 1. An employer is not obligated to provide private medical insurance for their employees. The law provides under Section 34 of the Employment Act that the employee should notify their employer of their illness and the need to seek medical attention. Thereafter, the employer should take reasonable steps in ensuring that the employee is accorded the medical attention that they require. However, I would like to reiterate that the provisions of Section 34 of the Employment Act only apply where there is no insurance scheme that has been provided for by statute. We have already noted that there is an insurance scheme that has been provided for by statute, which is the Social Health Insurance Fund, commonly known as SHIF, and it is provided for under the Social Health Insurance Act. This act mandates all employers to deduct Social Health Insurance Fund contributions from their employees' salary and remit the same to the Social Health Authority. Therefore, this is the mandatory insurance scheme that needs to be abided to by all employers. That marks the end of episode 7 of Employment Unlocked. But stick around for episode 8, where we continue to talk about the benefits under the Employment Act. You do not want to miss this. Thank you so much for watching and see you on the next one. Remember, information is power, legal knowledge is freedom.